So how's everyone feeling this week? How's the weather in your neck of the woods? Is it cool off any?
Well, like I said, I'm in northern Minnesota, so when you go norther, it's cooler, it's better. But I was looking on the assignments, the grading part of it. You were talking about there's a final quiz, final like test, but it's not showing. Is it going to be updated or what?
Yeah, it won't be displayed until like Monday.
Oh, okay. I'm like, I was a little confused. That's all.
Yes. Usually the modules are released one at a time, so everything in module 6 will not be visible until like Sunday night or Monday morning. So
Oh boy.
there's no quiz this week in module 5, but there will be a cumulative quiz next week and it's very hard. So you'll need to make sure that, especially that you read the chapters 4, 9, and 13, and then I will prepare a Module 6 quiz review video for your convenience. That should be of a big help, and I'll post that on Monday.
Well, that doesn't get, like, they don't give us much time because Tuesday night it's done, for 6. That really doesn't, I wish they would allow you to open it sooner, to give us, to get it time. Like in my last torts class, Kurt Olson, the professor in that class, he opened it up a little earlier, which really helped. So, because someone needed to get the stuff done early.
Uh-huh. I could
Yeah,
I could possibly open it Sunday night, sometime on Sunday.
that would be great if it's, then we can get head on it instead of going, being panicking, trying to get everything done within one day. It just doesn't work sometimes. So,
Yeah, yeah. That 5.5 week, that last week is very short in term 1. Term 2, it won't be as bad because for summer term 2, the term ends on a Friday, so you still get most of your weekend, but term 1, that last module is only 2 days. So yeah, I'll probably make the quiz available on Sunday, and the review video will be available like Sunday night. I'll post it. So you'll have a couple of days, and you'll get 2 chances to attempt to pass the quiz. Okay, let's get started. Welcome everyone to Module 5 in the contracts course. The term ends on Tuesday, August 10th. I just want to remind everyone this meeting is being recorded for the benefit of your classmates who couldn't be here, and in case you would also like to watch it later. So the reading for this week is chapters 4, 9, and 13. I would definitely recommend that you read those in preparation for the quiz next week. We're going to talk about electronic contracts. We're going to talk about some defenses to contracts. And we're also going to talk about how to do the Module 5 assignment, cheating the elderly, which happens far too often. So Module 5, Contracts in the Electronic Age. Our objectives here are to research requirements to form a contract remotely using computers and other electronic devices, choose clear and effective clauses to exclude warranties. We're going to look at illegality. We're going to learn how to research incapacity and undue influence, which would make contracts unenforceable or voidable. We're going to talk about fraudulent contracts, and we're going to be judging the ethics of working with incapacitated persons, such as elderly people who may have dementia and who may have be entering into contracts. Let's talk about unenforceable agreements. Infancy, age would be an issue. Legal insanity an intoxication, voluntary intoxication, illegal contracts that are contrary to statute, and those that violate public policy, covenants not to compete, and exculpatory clauses where one party tries to disclaim any liability. Those may be unlawful. We're going to talk about unconscionable contracts and determine when they are unlawful. Start with capacity. Now, in order to enter into a contract, an individual has to have the capacity to do so. Jody, the law presumes that parties to a contract do have mental capacity. That's a presumption in the law. Certain persons, however, do not have the capacity to contract, and they are minors who are too young, people who are mentally insane, and people who are intoxicated. So if someone is sitting in a bar drinking, as people often do, and they take out a napkin and offer to sell their house for $10, Jody, do you think that that is a valid offer to contract?
No, because he would be considered intoxicated. He is not coherent. He doesn't even know, the person doesn't even know what they're doing. So, no, it wouldn't be a valid contract.
Yeah, he lacks the capacity to enter into a contract. And most reasonable people would not take that seriously. You know, I just thought about Cheers. Did anybody ever watch that show in the 80s, Cheers? And Norm, I think he was the lawyer. They would all sit around the bar and chit chat after work. And, you know, barroom talk is not something that people take seriously. And they would not expect somebody to says, "Oh, I'll get rid of my sailboat for $5." No one takes that as a serious offer to enter into a contract. Reasonable people would not do that. So, no, an intoxicated person lacks the capacity to contract, even if they are voluntarily intoxicated. The common law of contracts and many state statutes protect persons who lack the contractual capacity from having contracts being enforced against them. Where would we find the common law, Adrian? Where would we find the common law? If I wanted to find out what the common law on capacity to contract was, where would I go looking?
Well, I would start with Lexis, or
Okay.
I would Google.
Okay. Is there anywhere else, Jody, that you might find the common law on contracts?
My home state laws, and which is the Minnesota Revisor, and I can look that up right there, and it'll state what's it's mostly 18 in the state of Minnesota.
Okay. Are there any other books, Jody, that you might look to determine the common law of capacity?
Oh, the treaties, the statements
Good.
of of contracts too.
Perfect. When you were looking up the common law on a basic contract doctrine, Adrian, you can actually start with the restatement if you just want to get an understanding of what the general law is when it comes to capacity or the ability of minors to contract. The restatement of contracts is a good place to start. Now, when you want to actually get more specific and find out what the law is in Minnesota, then you would need to get on Lexis, and you can choose Minnesota, you know, in your search box in your selection and look up recent statutes, or you could look up recent cases, and that would tell you, you know, what the specific law is. There is a time and a place to use treatises like the restatement of law, and it is when you just want to get a generalized understanding of an area of the law, like capacity or whether insane persons can be contractually bound. Okay, so because the law presumes that everyone has the capacity to contract, the party asserting incapacity as a defense to a contract bears the burden of proof. The party will bear the burden of proving the defense of incapacity. Let's talk about insanity. We see that more and more these days, don't we? Insanity. What's the rule on insanity? Well, people who are insane may disaffirm a contract. That doesn't mean that the contract is automatically void, Tina, not at all. Someone who is crazy could enter into a contract, and that contract could be valid if there's offer, acceptance, and consideration. However, they would have the defense of avoiding the contract. It might be avoidable. They might be able to avoid the contract, right? If someone has been adjudged mentally insane, and suppose they have a guardian, if their guardian finds out that they've bought a Corvette, okay, then the guardian may be able to disaffirm the contract on behalf of someone who lacks the capacity to contract. So they may be able to later void the contract. Okay. So here's the rule. If someone has been adjudged, determined in court to be insane, the contract is void. Neither party can enforce the contract. But if someone has not been adjudged insane, which is where most people are, right? Just a little crazy, perhaps, but not been determined by a judge to be insane, okay? Then, like I said, that's when the contract is voidable by the insane person or their guardian. The competent party cannot void the contract. So let's just get that distinction clear. If a person is actually adjudged insane, they lack the capacity to contract, the contract's void. If they're insane, but there's not a court determination, then the contract is voidable by the insane person. The person who was competent, though, cannot void the contract. Any questions on how that would work? Hopefully you won't be dealing with any crazy people. Tina says, who would void it? It would be their guardian, perhaps, their parents, Tina. Again, if someone is mentally insane and they've contracted to buy, say, a lot of weapons on the internet, and their parents, their guardian, or someone finds out about it, that person may be able to void the contract. Again, if they bought a house, someone who was insane bought a house and their guardian finds out that they're out buying real estate, they would be able to void the contract. It would be voidable, able to be voided. So it's important to get the distinction between something that's void, which has no legal effect, and something that can be avoided, because a contract that can be avoided can also be enforced. So if someone is insane and they buy a house and they make the payments and they live in the house, the seller can enforce that contract. The seller cannot void it, assuming the seller is sane and the buyer is insane. But the rule is different if somebody's been determined and adjudged insane in a court of law. Then a judge has already determined that they lack the capacity to contract. Everything they do is void. So usually the person who is insane or is a minor or lacks mental capacity, their guardian, their legal guardian would say, "What? You bought a Corvette?" and then void the contract. Intoxication is a defense. It's a contract defense. Most states provide that contracts entered into by certain intoxicated persons are voidable by those persons. The intoxication these days might be because of alcohol or drugs, could even be prescription drugs. The contract is not voidable by the other party as long as the other party has contractual capacity. So these are defenses where the person that lacks the capacity or their guardian can come up with a defense to enforcement of the contract. Let's talk about legality. One requirement to have an enforceable contract is that the object of the contract must be lawful. So, if I've gotten sick of my husband and I hire someone to kill him, is that enforceable, Adrian?
No, I mean, it's illegal.
Yeah. So, if the object or the subject matter of the contract is illegal, it is not enforceable. In fact, it's void. If the subject matter of the contract is illegal, it is void from the beginning. Neither party can enforce it. Now, most contracts that individuals and businesses enter into are actually lawful contracts that are enforceable. These contracts are this would include contracts for the sale of goods, services, real property, intangible rights, the lease of goods, property leases, licenses. Most contracts that normal people enter into are legal. However, some contracts have illegal objects. For example, suppose I live in California and my neighbor has a contract to meet his drug dealer in the parking lot to purchase cocaine. Jody, is that an enforceable contract?
No, because it's cocaine and it's illegal.
It is in California. What if they were in Oregon?
I have no idea in Oregon. I don't pay attention in Oregon.
Yes.
Some states I just don't know the answer. I don't pay attention. Sorry.
Yeah, I think I know in Oregon the personal use of most recreational drugs has been decriminalized. I'm still not sure about the purchase though of those drugs, whether that is legal. Here in Nevada, the use of recreational marijuana is legal. It's also legal to purchase it, but that is not the case on most places. You know, for example, in Oregon, it's actually legal to do heroin, whether or not
Oh,
you.
really?
Yeah, in the last election in 2020, Oregon legalized some harder recreational drugs. I don't agree with that decision, but that's what they decided
No.
to do, was to legalize some harder drugs.
In Minnesota, so far they're trying to push the marijuana as to be recreational. It did pass on one side and it was crazy. It's been crazy because they saw the one side of the House pass it, but not the Senate. So now everybody's using recreational. No, it's not legal quite yet, and it's a real toss up in Minnesota. They don't really want them to have it because it's become an issue, such an issue.
Sure.
So yes.
What see one this is just a side, but one of the problems is if you test positive for it in the workplace, you could still use your job. If you use drugs at home, you could have your parental rights terminated. So
Yeah.
there's still consequences for using these
Yeah.
drugs, and I've talked to some of the powers that be about that, saying, you know, you all are not looking at the next step, and the next step is that, you know, people need their jobs, and if you test positive, your job's gone. So I hope people are looking at that. It's looking at externalities in that next step. You know, if I do A, what happens? If I do B,
Yeah.
what happens? You know, and there's definitely still problems with the use of marijuana because employers don't allow it, you know, the family
Well,
courts don't allow it. And
it's still a drug that creates problems. I mean, I remember as a kid when it was illegal, and in Minnesota railroad, I will never forget this. There was an engineer that was driving a railroad train, and he was on marijuana, and he had a crash with it, single crash. Jumped the train off the track. Yeah, so it's like, nah, I think just keep it illegal. That would be better.
Yes, there's definitely public safety issues there. So, in any rate, any contract for the sale of recreational drugs in a state where they're illegal and in a state where it's illegal to sell and purchase them, that would be an illegal contract. Any contract that has an illegal object, I think a contract to build a casino in Alabama, right? I think Alabama is a state that does not allow gambling. So a contract to build a casino in Alabama, I probably has an illegal subject matter. I do not believe that that contract is legitimate. It's void from the beginning. Contract to sell gambling machines in Alabama, right? It's illegal. Gambling is legal only in a handful of states. It is legal here in Nevada. It's legal in Colorado. It's legal in Arizona. It's legal on Native American reservations in certain places. So, a contract to build a casino in Nevada is that's an enforceable agreement. It is not an enforceable agreement in Alabama. So that's an issue where you would definitely have to know your state law and you'd have to look up your state law, to find out what's legal there and what isn't. A contract to make a loan at an illegal interest rate, right? Every state has what's called usury laws that limit the amount of interest. That's why payday loans have been controversial because some of them involve, 360% interest per year. It's a question of whether that's a usurious loan with an illegal interest rate. A contract for a loan based on an illegal interest rate is void, null and void. Nobody has to pay back the money if they get a payday loan based on an illegal interest rate. Any questions about this? It's an area, again, which shows that the law is very much alive and it's changing. And we have to be aware of those changes. Illegal bargains. Contracts to perform activities that are prohibited by law are illegal contracts. We just talked about usuries. Contracts to commit a crime like the solicitation of a minor. That's illegal. Soliciting minors for sexual act or pornography. Sadly, that happens. It's illegal. Contracts that violate public policy. A contract that violates public policy might be one that restrains trade. It could be if you are a doctor and you join a medical practice group. There's usually like a non-compete provision in that, which says, if you should leave the medical practice group, you cannot start up a competing business within 30 miles. Certain contracts not to compete, if they're too restrictive, then they might violate public policy because, for the most part, this is a free market society. So somebody enters into a contract not to compete with someone. If it's too restrictive, it would violate public policy. Price fixing, that's when companies get together and agree to set prices. That would violate antitrust laws. I'm sure it happens, and these companies are not always caught. But price fixing between companies to make all of us pay more, that would violate public policy. Any comments about that? Let's talk about special business contracts and licensing statutes. Contracts that unreasonably restrain trade are held to be unlawful. We just talked about that. Price fixing, non-competition. States also have licensing statutes that require members of certain professions and occupations to be licensed by the state in which they practice. If a contractor has to be licensed to do work, and a contractor contracts on a project and performs work on a construction site, what happens when they try to get paid, Jody? An unlicensed contractor has performed work on a construction site and on a development and a product on a development project, what happens when that contractor tries to get paid?
It won't happen, you know. I mean, it's just there's going to be a contract dispute, and the, basically, no, it'll be almost voided, the contract, I believe.
Yes. Licensing statutes enacted to protect the public or regulatory statutes. Generally, unlicensed persons cannot recover payment for services that a regulatory statute requires a licensed person to provide. They will not be able to collect on that. Okay, the next area of contracts that are void are unconscionable contracts. And it's just like what it sounds. It's something that the contract is so immoral and it's so unfair to the consumer that it would just violate just the public conscience, to allow that. So the general rule is freedom of contract. In fact, the U.S. Constitution says no state shall impair the obligation of contracts. That's our forefathers, in particular Ben Franklin, believing in a free market system and really wanting to see free trade and the ability to enter into contractual agreements. So the U.S. Constitution says that no state shall impair any obligation on the right to contract. However, some contracts are so oppressive and manifestly unfair that they're unjust. To prevent the enforcement of such contracts, courts have developed at the common law the doctrine of unconscionability based on public policy. An example would be these tiny pre-printed forms that a consumer signs. If you purchase a computer on the internet and you see all these disclaimers and little tiny fonts coming up on the screen telling you to click that box, a lot of times it's an agreement to arbitrate, waiving your right to go to court for any lawsuit arising from the purchase of that computer or that item. Sometimes that will be unconscionable because the consumer can't even see what she's signing because of the tiny printed form contract. I think on rent-to-own agreements, people renting furniture to own, you look at that rent-to-own agreement and their printing is so small that the consumer doesn't know that he or she is signing her life away. That's unconscionable based on public policy. So despite what people say, the law is still looking out for the general public. That's one of the purposes of the law, is to protect the health, welfare, and safety of the general public. That is why certain contracts are unconscionable. Anytime one party tries to waive liability for a tort injury, that might be unconscionable. An example might be Carnival Cruises. Carnival Cruise, if you buy a ticket to go on a cruise and Carnival has on the cruise ticket, we're not liable for any injuries you suffer while you're on the cruise. A judge is not likely to enforce that if you slip and fall, on the cabana deck or something. To the extent that Carnival Cruise was negligent, you usually cannot waive liability for your own negligence. A business cannot get out of liability for their own negligence. Any type of, printing on a ticket to try to do that is unconscionable. Any type of provision that takes advantage of consumers would be unconscionable. So, any questions about what might be an unconscionable agreement? I think an installment agreement to purchase a car or a home that has a balloon payment in it, you pay $1,000 a month on your house, but then year 5, you have to pay $5,000. I know some people that have bought houses like that, and when the balloon payment comes, they're just scrambling. I think taking advantage of a consumer like that in any kind of installment agreement is unconscionable. Judges will not enforce something that's an unconscionable provision in a contract. The judge may choose to enforce other parts of the contract, but the unconscionable provision will be cut out of the agreement. What are the elements of unconscionability? There is a test to determine whether or not some provision in a contract is unconscionable. The following elements must be shown to prove that a contract or clause in a contract is unconscionable. 1, the parties possessed severely unequal bargaining power. The dominant party unreasonably used its unequal bargaining power to obtain oppressive or manifestly unfair contract terms. The adhering party had no reasonable alternative. Let's move on to e-contracts, which is what we're all doing now, it's with the pandemic, especially. Jeff Bezos really had a vision in the 90s when he was sitting at home with a personal computer in his garage, and he wrote the word Amazon on a piece of paper, and he was tinkering with this old out-of-date personal computer, and he was thinking about starting this company called Amazon. He literally was just in his garage with an old computer. And certainly Amazon has helped e-commerce just explode. And now we know he's a billionaire and he can, fly into space whenever he wants to. So e-contracts are now a way of life. They're not going away. In fact, everything is moving more into that direction. So contracts can also be created via email. E-contracts are electronically made agreements that are enforceable in court just as an ordinary oral contract would be enforceable or a written. They may or may not require an electronic signature. When would a contract require a signature, Adrian?
If it's over 500 or it's part of, or it's, land. There's a couple other elements too, but you have to have written and it has to be in signature with both parties.
Yes, the statute of frauds. So when the statute of frauds comes into play, an electronic contract, would still need to be evidenced by a sign writing to be enforceable under the statute of frauds. If something does not comply with the statute of frauds, it is not void. It is still can be a contract. However, it might be unenforceable, avoidable, or voidable. The party who did not sign the agreement might be able to avoid a contract. So the statute of frauds is another defense to contract. Someone says, "Oh, we got a contract." Well, show me the sign writing. I don't have one. The judge may say that you still have a contract, but the judge may say it can't be enforced. So the statute of frauds is a defense to enforcement. It does not mean the contract is void because it's not in writing. Well, with an e-contract, Adrian, one of the challenges is determining what are the terms, right? What are the terms? Consumer e-contracts, and I've had my friends experience this, consumers may not know the identity of the actual seller. Since many purchases online from small businesses are made by contacting businesses such as Amazon, eBay, Barnes and Noble, and Walmart's online sales. So these days, if you go to walmart.com and you buy something, like I bought an air purifier, right? We hear so much now about the dirt in the air and germs in the air. So I went to walmart.com and bought an air purifier. I could not return it because I found out that it was not being sold by Walmart. It was sold by some private seller who was just listed on Walmart's website. Have you ever experienced that? You bought something, maybe, and then you didn't really know who you were buying it from. You buy an item online, and I thought I was buying from Walmart, but I was not. It was just I was on their website. Yeah. Yes, yes. About 10 years ago, I was a seller on Amazon and eBay. I had some things at home that I didn't want anymore, and I would sell, or occasionally I would just be out shopping and I'd find some great deals on some things, and I would sell them on eBay and I would sell them on Amazon. Nobody knows it's me, right? They just click on Amazon and think that they're buying something. And that's great until it breaks. And then they contact me and say, look, I bought this item from you and now it's broken. That's when they know they're dealing with Kathy's Corner. That was the name of my business on Amazon, Kathy's Corner. So, but yeah, other than that, you don't really know who you're buying from. So, um, if you're it just encourages you as a consumer to be very careful. And when I buy something on eBay, I'm now clicking to see the rating of the seller. By the way, I had a perfect rating on eBay. I had one of the highest ratings. So, but I look at that now. When I buy on eBay, I'm looking at the rating of the seller. Same thing with Amazon. I'm looking, especially, there's things you can buy through Amazon and you're buying it direct from Amazon, an Amazon special, whatever. And then there's something that you're buying just from an individual seller who has listed on Amazon, right? So it's good to know the difference, especially when it's time to return that item. So these are some of the complexities with contracting online. You don't necessarily know who you're buying from or what the terms of the agreement are. You definitely have to, buyer beware, you have to read very carefully. One issue is a warranty. We all want that, right? When you purchase goods, you want a warranty that the item that you've purchased is actually fit for its intended use, or the seller will replace it if it is not fit. So an express warranty just means that the label of the product or any writing that you get from the seller says that the product is expressly warranted to be what it is. In addition to the express warranties that the seller states, the law has implied warranties. One is the implied warranty of fitness for ordinary use. This is also called the implied warranty of merchantability. And that just simply means, that the product is fit for what you expect it to be used for. The implied warranty of merchantability means that a seller guarantees that the product does what it is supposed to do. And if it does not, it fails the warranty. And then you are entitled to whatever remedies that the warranty would offer, whether it be that the product be replaced or, you get your money back. So that's the implied warranty of fitness for ordinary use. I sincerely doubt that any seller could disclaim that warranty because it is implied by law. The other is the implied warranty of fitness for a specific purpose. And this is when the seller knows or has reason to know the purpose in which the buyer is buying the product. When the seller and buyer are both businesses, a new contract is made specifying the purpose. So when the seller knows what you need the product for, there is an implied warranty of fitness for a specific purpose. The problem today is that businesses are trying to get out of warranties, right? Warranties are set by state law, so it's difficult for businesses to try to limit the warranty or exclude the warranty. A business may try to exclude the warranty of merchantability. That way they won't be exposed to a lawsuit. There are rules on how a business can actually exclude a warranty under UCC 2-316. An exclusion of the warranty of merchantability has to mention merchantability, be conspicuous. If it is not in bold, in caps, and in a large font, the exclusion is not effective. You should always avoid fine print. And that's a New Jersey statute that is saying that. Again, most states have adopted the UCC provisions. In fact, all states have adopted parts of the UCC. So you could look up your state law to get the state law UCC provision that pertains to the exclusion of warranties. But it's going to be very difficult for a business to get out of the warranty of merchantability. It has to be in writing and in bold caps, large font. So there's a knowledge check on warranties, and you want to make sure that you take the time to do that in the Module 5 materials because completing that knowledge check on warranties will help you prepare for the quiz. Let's talk about your Module 5 written assignment, which is cheating the elderly, it's sad that that happens, but it does. In this scenario, in your Module 5 written assignment, Joanne and Mary are helping out their grandfather who has dementia. They want to receive Jacob's, that's his name, his assets, but they're aware that they may be accused of elder abuse by their cousins or family members, so they've asked your supervising attorney to prepare a contract for Jacob, who has dementia, to sign. Joanne and Mary will do weekly housekeeping and look in on Jacob at least 3 times a week in return for the remaining funds, whatever money he has, payable over a 3-year period. They will not do any personal care, but will arrange for personal care as needed. Johann and Mary will each receive a salary paid by Jacob each month from his Social Security and his 401k, and a lump sum of $50,000 at the end of each year. Sounds like a pretty good deal for Johann and Mary. Should Jacob outlive his assets, they plan for him to go on Medicaid and assisted living at the state expense. So, what do you think are the issues here, Jody? Do you see any ethical considerations in making Jacob sign this agreement?
The incapacity, he is not coherent, able to, or have knowledge because of his dementia. So that kind of falls under insane.
Yes. Adrian, do you see any problems?
Yes, but I already have my paper written, so should I tell you my issues?
No, you don't have to.
Okay, but yeah, I found a few.
Tina, do you see any problems with this agreement? Well, yeah, one thing again is that Johann and Mary have an attorney, but who's looking out for Jacob's best interests, right? Yes, so this assignment is going to require you to do some research. It's going to be a lot of fun. Get on Lexis Advance and search any state. Put your the terms voidable contracts and incapacity in quotes. The reason is whenever you were searching a term, you don't just want to be searching for words voidable anywhere in the document, right? You want the term voidable contract to focus your term. If you want to put incapacity and elderly together, you could use incapacity and elderly person, and that will focus your search, because otherwise, if you just do a search on Lexis, yeah, Adrian, when I put it in quotes, it changed my search. Yes. It's called a Boolean search. If you don't use quotes, it is a natural language search, and that's just looking for words like on Google. That could bring up anything. You need to narrow your search, and the way you would do that is, go to Lexis Advance, search for, under cases, and put in quotes, voidable contracts. I would put in incapacity. I would also put in elder abuse. I'd put in dementia. I would type the word dementia into the search box and see if you can really focus and get a hit. That's your goal when you're doing research, is to get a hit, something that is very on point. And sometimes you'll get a case that's in the ballpark, and that's great, but I'd rather hit a home run, and if you can get a case that's really on point and as you're hitting a home run, that's the case you want. In order to get that case, you need to do a very specific search. So find and cite the most recent available case in any state that is on fast case, on contract law, and undue influence. Use this search or a similar search to get contract law. Avoid anything having to do with criminal law. The way you'll know you're looking at a criminal law is it'll be the people versus defendant or the state versus defendant. anytime the state is bringing a cause of action, that's a crime. We are looking for private agreements between individuals, and that's contract law. So one way to do it is undue influence, ampersand, and contract, not crim, and then the asterisk. Sort results by recent decision dates, you get the most recent case. Again, we don't want to look at old law that might be overruled. We want the most recent case that shows the most recent trends in e-commerce and what judges are thinking right now about incapacity. So then you're going to go back to the scenario and take a position on the legal and ethical issues presented in the scenario. Support it with your sources. Go ahead and use the IRAC method. Here's the issue. One issue is fraud or incapacity involved? And then the second issue is if the attorney does the contract and no attorney reviews it for Jacob, is that unethical? And we talked about that a few weeks ago about the attorney's obligation to inform an unrepresented party of their rights. So just be sure to complete the IRAC analysis, and by now you should be experts at that. You can use the IRAC table or the memo format. I prefer the memo format, but if the table is easier for you, that's fine. And, go ahead and use your own moral compass, express your own thoughts. How do you feel about this scenario? Be sure to identify your ideas on what the other side may say in response. One of the most important things in the law is to always be looking out for what the other side's arguments are so they don't, so you're not a deer in the headlights when the other side comes up with their arguments and their strategies. You should always be thinking, okay, what is the other side looking at? How would the other side argue this case? Is there a way to say that Jacob actually has the capacity to contract? Is there a way to say that this agreement is legitimate? So it's always a good idea to acknowledge the other side. So this assignment is due on Sunday, August 8th. Let's go over our end of the term reminders. So your live session question for this week is, what is the implied warranty of merchantability? Please submit that by Sunday. Just a reminder, Module 6 begins on Monday and ends on Tuesday. The live session video will be pre-recorded and includes a quiz review. Summer term 1 ends Tuesday, August 10th. No assignments can be accepted for grade after the term ends. And I will try to open up the quiz on Sunday so that you can get a head start on that quiz. However, no one should take the quiz without watching the quiz review video. But you do have 2 opportunities to pass the quiz. You get 2 shots at it. But I would certainly recommend that you watch the quiz review video before you take the quiz. Or you could take the quiz, watch the quiz review video, and then, take it for your final time if you want to do that. But I will open up that quiz on Sunday so that you have more time. Any questions about anything?
Yes, I always do.
Go ahead.
Would you like us to put an opposing opinion, or how, they may say, yes, Jacob's niece and nephew do have the contract is not unethical or whatever. Do you want us to put that in there? I mean, I have a couple of cases I can throw in there. So if that, do you want that part of the assignment?
Yes.
Okay.
Number 7 is part of the assignment, Adrian.
Oh, right there.
Is
Yeah, sorry. I'm so sorry.
identify
Yes.
your ideas on what the other side may say in response to your position. So yes, if you have a couple of cases and a few paragraphs that you could put in there, I would definitely recommend doing that.
I did. I just wanted to make sure. Okay, sorry. Thanks.
No problem. Yes, I will explain the Module 6 assignment also. Let me go into the classroom on Blackboard, and just take a look at a few things here, if I can. Module 5, contracts in the electronic age. Test your knowledge. So we still have 10 minutes of this live session left. So can everyone see my desktop? Let's do this test your knowledge. Now let's check what you remember. You will be provided with a series of questions. Question 1. The ordinary warranty that makes the most common sense. Warranty of title, implied warranty for a specific purpose, express warranty, implied warranty of fitness for ordinary use. The ordinary warranty that makes the most common sense. What do you think the answer to that is, Jody?
I'm still working on reading stuff, but I would say the implied warranty of fitness of the ordinary use.
What do you think, Tina?
It is the implied warranty of fitness of the ordinary use.
There's a clue. Do you see what the clue is, Adrian?
It's highlighted.
Mm-mm.
Oh, okay. I think it's the implied because it's already implied. I thought
It's
you
the
were trying
word
to throw me off.
ordinary.
Sorry.
Yeah.
It's the word ordinary, Adrian. The word ordinary is in the question, and the word ordinary is in one of the answers. Did you notice that?
Yes. Now that
Yes,
you said that. Yeah. Oh, sorry, Jody.
Oh no, I noticed that right off the back. Common sense. Click, click, click.
Yep, that's a clue. Sometimes, even if
Yeah.
you don't know the answer to a multiple choice question or you're stuck, look for clues. Okay. Number 2, the seller has reasons to know and understand the purpose of the buyer. When the seller and the buyer are both businesses, a new contract is made specifying the purpose. What warranty would apply, Jody?
Oh, excuse me. Applied warranty of fitness for a specific purpose.
Again,
Number 2.
yes, the word specifying is in the question, and a form of that word specific is in the answer. So if you knew nothing else, look for clues. Number 3, never excluded in a sale to a consumer because nothing is sold if the title is not good. What do you think the answer to this is, Tina? Which warranty is never excluded in a sale to a consumer because nothing is sold if the title is not good?
Title.
Hmm?
I'd say the warranty title.
The word title's in the question, and the word title is in the answer, isn't it, Tina? Good. Number 4, the label of the product should say what it is. Which warranty is that, Adrian?
I'm gonna go with warranty of no, sorry. Express warranty.
Yes. And the express warranty is the only warranty that would be in writing. The other ones that are implied. So yeah, if there's a label on a product that says this is what the product is, that is an express warranty. All right, congratulations. We got a 100. Let's just hope that that module 6 quiz is that easy. Okay, so thank you all for attending the Module 5 live session. It's been a pleasure having you in the course. Please be sure to submit the correct answer to the live session question by Sunday. And the question is, what is the implied warranty of merchantability? Any questions before we wrap up? Oh, thank you so much. Thanks, Jody. Thank you, Tina, for attending. Thanks, Adrian. Have a good evening, Jody.